4 contract categories. All real estate contracts fall into 4 specified contract categories. They can be 1. Valid, void, voidable, or unenforceable. 2. Bilateral or unilateral. 3. Express or implied. 4. Executor or executed. 1. Valid, void, voidable, or unenforceable. All contracts are valid, void, voidable, or unenforceable. An explanation for each of these conditions is listed below. Valid. If both parties fulfill their promises outlined in a contract, the contract is valid and enforceable. Void. If one party does not fulfill his or her side of a contract, the second party may sue to have the contract enforced by a judicial body. If one or more of the 5 characteristics is not present, for instance, a party member does not qualify to contract, see Section 1, Characteristics of Enforceable Contracts, the contract becomes void, cannot be enforced. For instance, if one of the parties has not been emancipated, the contract has no legal force or effect and is therefore not legally binding. A void contract can be disregarded. Voidable. If one party has used an illegal strategy or activity to get the second party to enter into a contract, the contract becomes voidable. For instance, if one party is found to have committed fraud, the contract is voidable by the injured party, and he or she may choose to repudiate, disaffirm the contract. A voidable contract cannot be disregarded. The party that would receive injury as a result of the voidable contract must take action within a reasonable period to have the contract ratified. Unenforceable. Chances are that if the terms of a contract cannot be agreed upon because of vague wording or poorly defined terms, a court will find the contract too ambiguous and therefore unenforceable. This is more likely to occur in instances when contracts have been established orally because the contents are more difficult to prove. Even if the law does not require that a contract is written, it is always a good idea to put it in writing. Additionally, as already stated, the contract must be clear. Take every reasonable measure to ensure the wording in your contracts is unambiguous and succinct. If the statute of limitations has expired on a case, the case becomes unenforceable, and the injured party can do nothing to legally bring resolve instead. Litigation is foreclosed. A statute of limitations is a statute in a common law legal system that sets forth the maximum period, after certain events, that legal proceedings based on those events may be litigated. Each state has identified a statute of limitations for contracts. This means that suit against a party involved in a contract must be done within a specified period. Otherwise, any legal claim will be lost permanently. Slept on its rights is a phrase used to describe a situation where a person has not taken action within a reasonable time frame, and is therefore no longer entitled to act on a claim. The official term used to describe this outcome is called laches, and it is an equitable defense doctrine. If ruled, it means that a party has waited so long that the delay has created an unfair situation for the opposing party and the claim can no longer be litigated. It has therefore become unenforceable. This is because the failure to take action on a timely basis misleads a party into believing that a breach has never occurred. Suppose that an adjacent property owner establishes a roadway on a portion of his neighbor's property to gain access to his storage shed, and he uses this new driveway for more than a year without hearing a word from the neighbor whose land the roadway is on. Because the neighbor did not assert his property rights in a timely manner, the doctrine of laches may allow the adjacent property owner to continue using the roadway for as long as he wishes. When writing or filling out AAR forms, make sure that you write exactly what your intent is. It is better to not add verbiage to the contract unless absolutely necessary. Do not write terms that are already stated in the contract under additional terms and conditions. Make sure that you think things through with scenarios that could happen. Make sure everyone understands the terms and understand the meaning and intent.